Has anyone ever stolen a social media picture of yours and passed it off as their own? Or have you found yourself on a dating app under a strange alias? All these examples could potentially be a breach of intellectual property law. And of course, it's nothing new. Today, we're looking at copyright, trademarks, patents, and trade secrets and their relevance in the digital age. In fact, I'm joined by Tumelo Mashabela from Chaya Mashabela Attorneys, just to elaborate further on exactly where do we fit in when it comes to copyright and the likes. Tumelo, thank you so much. A very good morning to you and welcome to the show.
Good morning, Faith. Thank you so much, and good morning to the viewers.
Let's talk a little bit about this. But let's first start off from a perspective of social media, but simply because the digital age and the digital social age is growing within the context of South Africa. And what we're finding a lot is, unfortunately, that a lot of these profiles that we see on social media are using photographs that are not theirs, people that are not them, to actually promote themselves. You'll have a man posing as a woman with a picture of a woman, and somehow this particular profile will be popular, and the poor lady can't even claim back her own profile, her own look, and the like. It's a growing trend, right? It almost seems as though it's unstoppable because the internet, to the largest extent, is not regulated. But where does the law come in when it comes to this?
Okay, so like you said, Faith, social media, it has it includes various intellectual property rights, and these intellectual property rights, it includes patents which protects your underlying concept. However, with regard to social media, the most important intellectual property right is copyright. So copyright protects that photo, it protects a song, it protects the manner in which you are illustrating a particular material. So, for example, if somebody has taken your photo, that photo is protected by copyright. So you can institute copyright infringement. However, social media, for example, your Twitter, your Facebook, they have their own policies in which you can actually go through them to ask them to remove a particular photo. So you need to ensure that you follow their guidelines and reach out to Twitter or Facebook and ask them and illustrate to them that somebody is using your intellectual property, and ask them to remove that particular intellectual property right. So the internet, it's a bit tricky. It's not like you're saying, it's not like your normal way of doing things. It's very easy for people to steal your intellectual property and not to even be accountable. But these social media platforms, they have policies internally, and I urge people to actually follow and read those policies and actually reach out to Twitter as well as Facebook to ask them to assist them in removing their copyrighted material from other people's profiles.
You know what the sad part is? I'm starting to see more and more verified profiles of people which are not even the real people themselves. And these profiles are verified, So in that case, it seems as though we consistently are fighting this losing battle because, as I said, the greatest part of the internet is unregulated. Yes, social media platforms have got these policies, but do they even follow their own policies?
Yeah, no, that's true. I mean, if you're saying the verified profiles with incorrect pictures, I mean, that's a problem, because I think we are all following or believing that because something has been verified, Twitter or LinkedIn or whoever has actually made sure that they confirm that particular profile. So if they are not following their own policies, I guess it is a problem, and it leaves us without much protection, unfortunately.
Yeah. So let's talk a little bit about the creative industries in general. Creators will often say to you, listen, I have got the best of ideas, but every time I share an idea, that idea, I see it either on TV, or I hear about it on radio, or I see a billboard, and I think to myself, but I've sent these guys proposals of this very same material, right? And sometimes these people will even have traces and even emails to say, kindly find attached my proposal of whatever so-and-so, and they struggle to prove it. Because unfortunately, the big corporations have got lawyers. You as an entity are only trying to find you break within the industry itself. So how is it that creatives get to protect themselves? I mean, you're talking about copywriting, but can I copyright even my PowerPoint presentation? How do I get that protected?
Okay. So, like I said, there are different types of protection. The easiest way is a patent, because with a patent, you are protecting your underlying concept, and you go and register at the CIPC. So it's easy for you to prove ownership of a patent. However, with copyright, like you're saying, because it's a non-registrable right, it exists automatically, so you don't have to go through any protection to obtain protection for your copyright. So it exists automatically. The only thing is that when time comes where you have to prove ownership, you have to, for example, pull out your drafts. You have to pull out, all the work that that you did before. And that's what normally I advise entrepreneurs to say, that make sure that with regard to copyright, you have all your drafts, you have, all your mock-ups, you have everything, so that if there's ever a dispute with regard to ownership, you can actually illustrate to people that you own that particular copyrighted work. However, your question with regard to, I went and I presented this to potential investors or to whoever, and eventually they took out my idea. That happens very regularly, and I always advise entrepreneurs to say that, or creatives to say that, before you actually start talking to people, you need to ensure that they sign a non-disclosure agreement. And I know a lot of people are saying that,
Does it even work? Is it relevant in South Africa, though, an NDA?
An NDA, I always say, it keeps an honest person honest. However, you are actually at least doing something. So when you ask somebody to sign a non-disclosure agreement, you are actually saying that, what, this is my intellectual property, please do not disclose it, beyond this. However, there is, unfortunately, if you don't allow them to, if you don't ask them to sign a non-disclosure agreement, the moment you walk out, nothing stops them from going out and talking about that technology. And another thing that you can actually do is that when you go to these potential investors or whoever, maybe make sure that your documents are encrypted, or you find ways to protect your documents so that they don't get to steal that document. Sometimes I always tell people that even if when you send an email, in the subject line, make sure that it is confidential, or mention that this is my intellectual property. Because when it comes to you arguing that it is your IP, unfortunately, it is going to be based on you being able to prove that it is your intellectual property. Unlike if you had a patent, and with a patent, like I said, you can just show a patent registration certificate, and it is easy for you to prove.
But Tumelo, a patent is expensive. It's not, unless you can begin in the beginning process, but to get it fully patented, there's a cost involved.
There is a cost involved. However, I always tell entrepreneurs as well that the first part of obtaining a patent, you can do it yourself, and a lot of people are not aware. You can file a provisional patent application at CIPC, and it will cost you about only 60 rand. Yeah. And once you have provisionally reserved your rights, you then start talking to investors. And I've had entrepreneurs who say, Tumelo, the investors started listening to me, the fact that I had actually made an effort to sort of provisionally protect my intellectual property. And intellectual property, it gives you an opportunity, or it opens access to funders. There are other funders that looks at you differently because you have at least filed a provisional patent application. So a provisional patent application, you can do it yourself. Yes, I agree that when you have to file a complete application, you need a patent attorney. But at least by that time, you have reserved your rights, rather than starting to disclose your invention prematurely and only to find out that you can't even file a patent for it because you have disclosed your technological solution.
I feel like you need to open up a school with that. Tumelo, much appreciated for your time, and thank you so much for joining us. I think you've opened our minds up a little bit further, especially about how creatives can better protect the work that they do, because it's very tough out there. It's nothing worse than seeing the work that you've put in and the effort that you've put in being taken by somebody else and somebody else profiting off that. But of course, Tumelo Mashabela joining us from Chai Mashabela Attorneys.